Welcome to everyone to the webinar on Shadow AI. Your employees are already using it. Are you protected? My name's Ryan Healy. I'm pleased to welcome our expert co-hosts today, LegalVision's very own Callum Kilgour-Aiken. He's a senior associate, and Thibaut Williams, founder of cybersecurity firm TMW Resilience. Now, before we begin, a couple of quick housekeeping items. So you'll receive a recording of the slides in your email, and excuse me, I'd like you to submit your questions in the Q&A box, and we'll answer them at the end. So if you can complete the survey afterwards, that'd be really great. By viewing the webinar, you are eligible to receive a complimentary consultation with LegalVision to discuss how we can help your business. To claim, just leave your contact details in the survey that appears when the webinar ends, or contact us via our website. So on today's agenda, we're going to be discussing Shadow AI, what is it and why it matters, the risks, so cyber, privacy, liability, and IP, the UK regulatory picture, building a defensible position, policy, controls, and evidence. We'll then move on to responding when something goes wrong, and we'll have a Q&A session at the end. So just on the sort of first topic and first question, Shadow AI is one of those risks that can sound abstract, but in practice, it often starts with something very ordinary. So an employee using AI without the business's knowledge, usually to speed up their own work. So I'd like to know what you're both seeing in businesses right now, and why leaders should be paying attention to this. And Thibaut, I'd like to ask you that question first.
Sure, thank you. I think the biggest thing that I'm seeing in businesses is twofold. The first is everybody's in awe of AI and all these wonderful tools out there. And don't get me wrong, there are some really, really incredible ones that can do amazing things. But people have forgotten the old mantra of the internet, that if something is on the internet for free, you are the product. And every time you use it, if it's free, it is taking what you've put in there, how you used it, why you used it, everything else, and it's learning something. And they are making money from that, either directly or indirectly. But the second thing I'm seeing, which is really starting to bubble up a lot now, is people trying to connect two tools together. So Claude is very good at this. You add skills, you add connectors, you add all sorts of things, but they don't check those before they connect them. And there's quite a lot of evidence on GitHub that there's a lot of skills that are being published that people are putting prompt injections in them. So as you run it, it will very silently put another query in and say, send that information again to somebody else, and those sorts of things. And so people are not aware of the real risk that the Shadow AI is giving.
Yeah, sure thing. And Callum, what are you seeing in businesses right now, and why should people be concerned or at least paying attention to it?
Yeah, so it's something that Thibaut's touched on there, but it's probably something that a lot of businesses are seeing now is employees using things like ChatGPT to draft emails, code, reports, and documents, etc., things like that. So that creates a bit of a risk because where you've got unchecked usage, you're bypassing what we'd classify as like corporate or legal security. There's no legal controls, which ends up exposing the business to either regulatory or commercial liabilities. Shadow AI is pretty hard to track, but because, as Thibaut elaborated on, the tools are actively processing and learning from the data that's inputted, the risk of sensitive data being input and then out into the internet kind of forever is a real risk for businesses. So you end up exposing yourself to potential data exfiltration, which can give rise to ICO penalties. So it's really about trying to identify early on and mitigate these risks as best you can.
Okay, thanks. And I think, Thibaut, directly for you, from a cyber breach perspective, what can happen once staff paste that customer data, contracts, financial information, or commercial material into a public AI tool?
Just about anything. Depending on the tool, depending on where it's gone, you've lost control of it. What people need to understand as well is what threat actors do is they look for trends. So if they start seeing that a certain tool is actually quite easy to do a prompt injection, they'll just start doing more and more and more of it. And they won't act on any of that data straight away. The longer they can keep up that cyber threat and more people using it, more and more data coming out, the better. So it's not as though a threat actor is going to sit there and you put one piece in and they're just suddenly going to grab that and run away with it. If they see one piece, they'll wait for the next piece and the next one and the next. And as they build up that evidence or that loss, the harms to you just grow exponentially.
Okay. And Callum, I suppose similarly, but more from a privacy, UK GDPR perspective, what are the main legal risks when a business doesn't know what AI tools staff are using or what information is being inputted into them?
So the primary risks can probably be summarized as a lack of audit trails and risk of data breaches. As I mentioned before, shadow AI typically involves unauthorized data processing. So that means you may not have established a lawful basis. You can't legally then process data. You can't enforce purpose limitations or protect data subject rights, which are all requirements under the GDPR. And you might end up having unlawful international data transfers as there may not be adequate cross-border safeguards. So under the GDPR, a business might be a controller, a processor, etc. And then when there's a transfer of data, it's important that the necessary documents are in place, such as a data processing agreement. And if it involves cross-border transfers, then you might need the standard contractual clauses in there. So when these aren't there, if then an employee inputs personal data into a public AI tool, they've potentially disclosed that information without transparency, consent, without a compliant data processing agreement, which gives rise to potential liability under the GDPR, gives rise to ICO fines potentially. And it just, from a practical perspective, it impacts how business might respond with the 72-hour notification period with the ICO. If you don't know that a data breach has occurred, you can't realistically go and identify that, carry out the steps that you need to do, which are all mandatory under the GDPR.
Yeah, of course. And I think tech is moving faster in some cases than legislation. And certainly the UK's approach to AI regulation is still taking shape. So whether you're operating a business in the UK or the EU, where do things stand today? And what should businesses be tracking so they can plan ahead rather than scramble to catch up or reactively respond?
Yeah, it's a good question, and you're definitely right. The law is dragging a bit behind in terms of, there's a lot of tools out there, a lot of contracts being signed and data being sent out into the internet. So the UK is a bit unique in that it doesn't have what we classify as like a single act or piece of legislation. It operates more in like a regulatory framework. So it relies on existing regulators to apply principles across different sectors rather than one act like the EU AI Act, which makes it difficult for businesses because you end up having to track specific sector regulatory updates in which the context of you're using AI. So one example of this, the ICO themselves have posted some guidance on the use of AI and data protection around the principle of accountability for the use of AI in terms of protecting personal data, preparing DPIAs and stuff like that. So I guess because the UK has taken such a bit of a lax approach, cross-sector principles like safety, transparency, fairness means that regulators have to apply that to their own domain. One thing that I do think is worth knowing is that for UK businesses, even though they may not be subject to EU law, if they're operating in the EU, things like the EU AI Act will apply to them. From our perspective, we're not EU lawyers, so we can't provide specific kind of advice on whether it's compliant or not, but there's a separate regulatory framework in terms of identifying risks with AI and AI tools that they will need to get advice on. So it's, every country has got its own different processes, and it's just about identifying where you're operating your business and what the risks are, and then taking steps to mitigate those risks there.
Okay. And I suppose whilst we're still on that, Callum, I'll stick with you on this next question, and then Thibaut comes to you next. But if or an AI tool produces inaccurate, misleading, or unauthorized output, and that output then goes to reach a client, customer, or the market in general, who's likely to carry the responsibility? Is it going to be business, employee, or the actual tool provider themselves?
Yeah, it's another good question, especially with how prevalent AI use is these days. There's probably two perspectives to look at it. Firstly, I can touch on it from a legal perspective. Thibaut probably has more of a practical view of things, but from a legal perspective, it's essentially always the business that will be liable to the client or the customer. There's a legal concept of what we call vicarious liability, which means that, broadly speaking, employees, when they're carrying out tasks or duties in their ordinary employment, their employer can be held liable for what they do while they're employed. So ultimately, if an employee is using shadow AI, even if the business has no oversight of that, there's a really real risk that they will still be held liable if there's an output that goes out there, infringes, breaches, contractual terms, etc. So I guess it's worth noting that's the same even if there is an enterprise tool. Ultimately, it's important that human oversight and input is involved in all usage of AI. But where you don't know that your employees are already using AI, that creates a bigger risk. And so that's where you try and put your policies and procedures in place to mitigate those risks.
All right, thank you, Callum. And Thibaut, same question. Where does the responsibility sit?
I tend to look at this pragmatically and go, if any employee did something wrong, who's liable? Who's responsible? It's always the business. Whether you like it or not, your employees are representing your organization. And so if they are putting forward incorrect information, it's the business. The best example is in Australia with Deloitte and how they gave some false information to the Australian government because they outputted it from AI and they didn't check it. Who's responsible? The name of the individuals or individual persons, don't know who were involved, did it aren't in the newspaper. Deloitte's name is.
Mm-hmm. Okay, and I think Callum, again, I'll come back to you. So, what IP issues should businesses be thinking about when staff use AI to create documents or marketing content, code, images, anything that's used for commercial work? So, for example, who owns the work that AI helped to create, and what are the copyright risks?
Yeah, so there's a few elements to this one here. So firstly, what could originally be considered IP, like trade secrets, source code, etc., could be leaked into the open through OpenAI tools. At that point, you kind of lose the protections around that where it becomes in the public domain. So that's one thing to consider. Secondly, where your employees or your staff are using enterprise tools to carry out tasks, produce outputs, and there's not a sufficient enterprise agreement signed to make sure that there's the proper checks being carried out, then you may end up with inadvertent infringements on third-party rights or copyrighted materials if the output is replicating something that's already protected for another party. So you have no oversight of what's happening in respect of that. And then finally, it's a bit of a gray area in respect of the actual copyright of outputs that are produced by AI. So the starting position is in England and Wales that copyright in computer-generated works is protected. So computer-generated works is where there's no human oversight or human input. There's no human author. So that will typically vest in the party who is, using the AI, inputting the prompts, putting instructions in, etc. But it's important to note that's not definitive. So the terms of a license agreement can actually override that default position. So it may be that some agreements or some terms grant certain rights to the owner of that tool themselves. So that's why it's important to know and have oversight of what tools are being used by your employees, so you can be clear on where ownership and copyright falls when outputs are produced. I think it's also good to note there must always still be, a sufficient degree of human input, skill, judgment, etc., for copyright to subsist in any AI-generated outputs.
Of course. All right. Thank you, Callum. So I think I'd like to come to you next, Thibaut. What are the practical warning signs that a business has a shadow AI problem? even if no one's formally approved the use of AI?
There's a couple of easy wins you can do here if you're worried that the shadow AI in your organization. There's a couple of more technical ones. The easiest one is there are telltale signs. Most people today know about long M dashes. ChatGPT is very, very good at doing that. It always leaves a long M dash, and unless you remove them, it's quite easy to see. They're also very they use hyperbole a lot. They're also very, I mean, if you go a bit further, some people would say AI tools are very sycophantic, and so you can often tell from the language. You can also see if you go on LinkedIn and you scroll for I'd call it about 5 scrolls, you'll see 4 or 5 people having produced maybe a PowerPoint slide or something like that, and it'll be a very, very similar template because Claude, for example, uses a particular style of PowerPointing. So things like that are the kind of subtle telltale signs. More technically, if your organization is doing any monitoring or logging, you'll start seeing more signals on endpoints. You'll see events. You'll see a lot of monitoring software now includes SaaS searches, so it will automatically detect a new SaaS tool has been being used in the organization. Things like that. It's those that will pick up as those increase over time. It'll start telling that actually starts being the signals that there's shadow AI being used.
Okay. And blanket bans on AI tools tend not to work in practice. So what does a realistic enforceable policy look like? And what controls should businesses have in place right now, Thibaut?
So if you will indulge me, I'm going to give you a little story on this one.
Yeah, please.
I was asked by a friend of mine to come and see his CFO at his business. Works in a fintech company, and their last quarter was their best quarter they'd ever had. Right, it was almost as good as the previous year. It was incredible, and they loved this. They started to investigate, and the CFO found out that basically the staff were using 3 different AI tools: complete shadow AI, no regulation, nothing. And his reaction was to completely block everything, cut everything completely, got to IT, blocked it down so hard that their following quarter was the worst they'd ever had, which I suppose anybody could have predicted for him. But I was asked to have a conversation with this person just as a person of interest to say, look, there's a better way. And I'm a firm believer that in terms of the new technology like AI, trust your staff. If you are seeing your staff coalescing around a certain set of shadow AI tools, simply banning them is not the correct option. The correct option is to start going, okay, let's understand why you've all chosen that. I've seen an organization which was firmly a Microsoft project organization start to discover that people are using Monday.com. By the way, I'm not endorsing either. But the question is, why are you using Monday.com? Well, because it can do ABC. Okay, so that's your staff indicating to you through your shadow AI, we've found a better way to deliver the output. Surely the most important thing is the output. So I would always advise somebody, if you found the shadow AI, great, run an audit, log it all, understand why it's being used, and then pick one, right? So if your staff are using those 3 tools, go and get a license for them. The point that Callum and I are trying to make to everybody here on shadow AI is the unlicensed one, the one you don't know about. Go and get a contract, go get a license, go to that supplier and say, we would like to use your tool, but we want proper contractual terms, data processing agreements, so on and so forth. And all of a sudden, you found a way to positively take a direction your staff want to take, given them a tool that they've said themselves they want to use to give you the outputs, and you've secured it. It's a win across the board.
Mm. Yeah, 100%. And thank you for sharing the story. I think Callum, same question to you.
Yeah, to echo what Timo said, by implementing a blanket ban, you're effectively just encouraging your employees to not disclose the tools that they're using. And that just ends up creating a bigger risk long term. I think it's pretty clear from what Timo and I are saying, with proper training and oversight, AI tools can be extremely beneficial for efficiency, productivity. So you want to harness that and make sure you've got the proper policies and procedures in place. So a realistic policy from a legal perspective would list AI tools, ban the input of confidential or personal data into public models, approves or sets out an approval process for new tools that are being examined. And it needs to provide guidance on what the tools are, the boundaries around using them. From I guess, a slightly different perspective, that also helps if then later down the track, your employees are not following your policies. You can then point to that and say, well, we have a policy in place. If you end up in employment, disciplinary proceedings, to say, this is a policy, we gave you training on that, you then chose not to follow that. So you kind of get a benefit there as well. And then from a broad perspective in terms of kind of additional controls, you want things in your employment contracts, regular training. If things have been identified as high risk, maybe you block that outright, but it'll be a little bit business dependent in that respect as well.
Yeah. All right. Thank you, Callum. So if a regulator, a client, court asked what the business had done to manage those risks that we've spoken about, what evidence would help to show that that business had taken the reasonable steps? I think, Thibaut, I'd like to come for you first.
Sure. I mean, if you look at, there are, last I checked, there are 63 different AI regulations in the world. EU Act, Chinese Act, California Act, all over the world. They all coalesce around the same principles: governance, risk, and repetition. So if a court wants to know what you did, what governance have you done? What have you done to understand what is being used, how it's being used, why it's being used, and what have you done to put a policy in place to state what can be done? Then, how have you understood your risks? Have you looked to understand your risks? Have you tried? Have you mitigated those or accepted them, which is fine. You're allowed to accept a risk. There's no reason you can't. And have you made a repeatable process? That's how you can demonstrate trust. Now, is that going to stop you having a problem? Of course not. But it's going to demonstrate to any regulator, court, or whatever, any enforcement action, that you have made a genuine attempt to govern your AI correctly so that it doesn't happen. If something still happens, they're more likely to give you an easier ride because you've tried than if you hadn't.
Yeah. So there's due consideration taken for every step.
Absolutely.
And Callum, same for you. What, I suppose, from our perspective, from a legal perspective, what evidence would we support in helping show that businesses taking those reasonable steps?
Yeah, so like I was talking about before, a documented acceptable AI use policy that clearly sets out, the tools that are approved, what's not permitted, signed employee acknowledgements, records of staff training, a register of approved AI tools with completed data protection impact assessments. And to echo a wee bit what Thibaut was saying there as well, if you're audited and there's an issue, regulators and courts look for, have you taken accountability? And is there a paper trail to show that you've identified the risks and you've implemented technical or organizational measures to mitigate them rather than just turning a blind eye? I think it's important to note that, a serious documented attempt to take control, so internal audits, reviewing policies, carrying out risk assessments and stuff like that, as opposed to just doing nothing, will help significantly reduce any potential liabilities, fines, etc. like that. And as Thibaut was saying, if you can show that you've taken steps to mitigate your risks, that's going to significantly help your starting position. Yeah.
Okay, thank you. My next question is almost going to use the story that Thibaut was talking about before. So I want to let's look at a concrete example. So a staff member's been using an AI tool for 6 months and nobody knew. A data subject complaint has come in. What are the initial actions that the business has got to take immediately? Callum, I'd like to come for you first.
Yeah, so again, there's probably a few elements here. So the first would be containment. So as much as we said, no blanket bans, when there's potential data leaks, breaches, etc., it's important to revoke access to the tool, secure the data. You need to provide instructions to the employee to stop entering personal data into the tool. where you can delete or remove that personal data, but at the same time, you want to preserve logs, prompts, account records, any other evidence that you've got. Secondly, you'll need to pretty quickly establish the facts. So what tool was used? What are the terms of that? Does it train on inputs? Does it send data abroad? What personal data was inputted? Whose personal data was that? And then look at the actual complaint and see what it alleges. So as part of that process, you'll then need to assess whether it's a personal data breach under the UK GDPR. I guess it's important to note that that also extends to unauthorized disclosure or access, not just loss of data. So feeding personal data into a tool that retains it or is training on it usually qualifies as a data breach for that. And when there is a personal data breach, you've got 72 hours from becoming aware to notify the ICO, unless it's unlikely to pose a risk, which is probably unlikely to be the case in these circumstances. You've got to disclose individuals if it's a high risk to them, and then you need to record the breach as well. At the same time, you need to handle the complaint kind of in parallel while you're doing everything else. So you need to treat any rights request in terms of access, erasure, objections within a 1 month deadline, and then you need to investigate, respond to their complaints, and kind of in the background of that is bearing in mind that individuals can escalate that to the ICO and request compensation for that. So that's kind of the immediate steps. In terms of after that long term, that's where you then need to identify your compliance gaps. You probably need to deal with the employment side of things in terms of making sure there's policies in place, there's clear instructions to employees, and then make sure you update your records of processing and your breach log as well.
Of course, lots and lots of moving parts, and lots to consider even in the first few steps. So, Thibaut, same to you. What are the initial actions a business must take?
I mean, I think those Callum covered them pretty well. I think the single biggest one I would also say that a lot of people tend to forget: stop. If a data subject access request has come in for that in this scenario where this person's been using it, nobody knew, the very first thing you should do is stop. Stop using the tool. Just literally disconnect it. Do not do any more processing. For two reasons here. One, because obviously we need to look at the data subject access request, but also because we didn't know about its use. The last thing you want to do is let that continue, and through the data subject access request review, someone like Callum looks at it and goes, "Oh, actually, this is still processing really badly," and meanwhile it's been running in the background. Mm-hmm. So stop. Think of the fire drill. I think it's the US one. Stop, drop, and roll. Stop. Do your due diligence for your subject access request, and then keep going. But yeah.
Okay, thank you. And for the people that have joined the webinar today, what are the first 3 actions that they should take after this session to reduce a data loss and build a defensible position? Thibaut?
For me, so I'm going to assume everyone has a fantastic relationship with all of their employees. So you're going to ask them very nicely, and you're going to have an amnesty. And you say to them, please tell us what AI tools you are using. And it must be an amnesty. If it's not going to be an amnesty, if anybody's got a fear of losing their job or any sort of repercussion, they're not going to tell you. Get them to tell you. And start building an AI register. Okay, so you have 2 tabs in your register, the register that you already have all your contracts for, and you should have an AI register regardless, that sets out what the T's and C's, the location of the data processing, so on and so forth. But your other tab is here's your shadow ones. Step 1, get that information. If you need to, go to whoever manages your IT and ask them to start running scans to see if they can identify any other tools. If you're using Microsoft and Sentinel-1's very good at it. If you use something like Huntress or any of the other kind of third-party SOC tools, they should be able to tell you as well. There are ways to go and find out. Number 2, start working with your employees. And please note what I said there. I didn't say go and look for yourself and decide which shadow tool. go and work with your employees to understand why they've used these tools. What is it about these tools that they've used? And then third, as I said earlier, go and secure those tools. Now that might mean getting a contract, it might mean putting it into a local version, it might mean removing certain abilities, things like that. Go and secure it. And can I just add one kind of 3.5 on that, just because a common complaint I get about that is, but I'm a small business. I can't negotiate with these big companies. You'd be amazed. You'd be amazed how many of them are ready to negotiate because they're all trying to break open into the space. Give it a go. And I'm sure if you give it a try, you can have a look. Now, if you've got a shadow AI tool that you literally cannot secure because they just won't give you they won't do the terms you want, then you go to your employees and say you can't use that one. But we're going to go find the one that can, because we now understand what it is you require and what it is you're looking for. And that will make a big change. It'll make a big change in your organization if you're operating like that.
All right, Thibaut, thank you very much. Appreciate it. Well, everybody watching, that concludes the main part of the webinar, and you might find our publication useful. So I'm just going to pull it up onto the screen. You should see a QR code. It's a free download to our UK privacy policy checklist, and it's all about what your business needs to know. Now, just with regard to our next webinar, so that's going to be on managing cyber threats and what to do when your business is hacked. That's going to be hosted on Tuesday, the 21st of July at 11 a.m. BST, and you can register at legalvision.co.uk/events. I'm going to talk to you a little bit about our membership shortly, but we are going to answer some of your questions. So whilst you're submitting them, I'll tell you a little bit about how LegalVision help our clients and what that looks like. So by becoming a LegalVision member, your business gets unlimited access to our full team of specialist lawyers for all of your business as usual legal needs. So our team can assist you with unlimited document drafting and reviewing. This is contracts, policies, and so on. Unlimited legal advice consultations, and unlimited domestic trademarks, and much, much more. So as a member, you don't have to worry about the cost of lawyers. So think of it as having your own in-house counsel, but we take care of all of the business as usual legal work, so you can focus on running your business. If you are an in-house legal counsel, we also offer a dedicated service to manage your high-volume BAU legal tasks. If you want to learn more about our membership or desk extension services, then you can request a free consultation with the survey that will appear at the end of this webinar. Also, for any questions, I'm going to bring up Thibaut's contact details too. So you'll see Thibaut's email on the screen. So any questions for Thibaut or any inquiries to make for Thibaut, you're more than welcome to get in touch. I am going to hand back over to Callum. And while Callum's going to answer your questions, you'll see a poll pop up. We'd really appreciate it if you could answer it.
Awesome. Thanks, Ryan. So one question that I think is probably good to address is, and it's a wee bit what Thibaut touched on around, a vendor is refusing to negotiate their terms. What should smaller businesses do in that situation? And Thibaut covered it pretty well. I think from our perspective, it helps to get legal advice because we can then, provide value to you in terms of, what are the key risks that you need to consider? Things like we've touched on throughout, what policies and stuff do you have in place? Because although you may not be able to get across the line in terms of some specific terms, you might be able to agree others that you ultimately decide, okay, well, given that this tool is really useful and our employees really want to use it, we're happy to acknowledge these risks, we've mitigated these risks, and that we're happy to kind of proceed forward with that tool, noting everything. So legal advice is really important to help you understand the wider picture. Obviously, coming into it from a business perspective, you've got a certain view. And so that's why legal advice can help you just to consider some things that you may not have otherwise thought about. Secondly, it's probably just around, reviewing, updating governance policies. How often do we need to do it? Do we need to do it? this will probably depend a wee bit on the use of AI in your business and the risk element to you. But from our perspective, we would generally recommend reviewing AI governance policies every 6 to 12 months, if not more frequently, rather than treating it as just a one-off kind of compliance exercise. It's done, forget about it, don't worry. As we've discussed, there's a number of different acts. The law is always changing. What might be the case now may not be the exact same in 3 months' time. So that's very important to get a health check, get a legal review of your documents, make sure everything's in place. We can help set out, the policies and procedures for dealing with your employees and your staff. And then it's also important to show as part of your audit trail that if you do get audited or if you're being, inspected by a regulator, that you can point back and show this evidence. Well, we've had reviews carry out with our lawyers every 3 months, and we've done these policies and procedures, and we've done this training. This is in our employment agreements. And so you're able to show that you've taken steps, as I said earlier, to mitigate those risks around that. So although there's not a specific kind of, you need to do it every so often, we would generally want to err on the side of caution in such a space that's just always changing. There's always new things coming in. There's new models, etc.
Thanks very much, Callum. So thank you for completing the poll for everyone that has done. You should have also received a message in the webinar chat today, but I'll just cover that quickly. You are eligible to enter into our monthly prize draw for a chance to win some Apple AirPods. So you just simply have to share your contact information. The link should have been sent to you. So that'd be great if you could also enter that too. So that's all we've got time for today. I'm really sorry if we haven't answered any of your questions. Feel free to submit your details in the survey at the end. We'll give you some assistance with any questions we didn't answer. You can learn more about how our membership can help you. And while this is a free webinar, we do really value your feedback. So please complete the 30-second survey at the end. And thank you so much for joining us, and enjoy the rest of your day.